Hi everyone, my name is Beverly Allen. I'm a Tacoma-based attorney and I've been practicing family law for 10 years. Today I'd like to talk to you about filing a dissolution of marriage in Pierce County without children. So the good news is you've already eliminated most of the areas of disagreement just by being in this status. So I know this is an awful process for you, but congratulations, you've made it easier, as easy as possible. And so I highly recommend that you purchase the packets for dissolution of marriage from the Pierce County Law Library. This video will assist you in using those that packet of information so that you can be prepared for success. So these packets are $20 and they're a way for you to have everything all in one place so that you don't have to go looking for information. If you need to redo something, re-download something, well, first of all, you can use whiteout or you can cross things out and make edits. You can also go for different forms to courts.wa.gov/forms. The documents that you have on this packet do correspond to the document numbers on courts.wa.gov. So what's in this packet here? Confidential information form, that's the first form that you'll see. That piece of information, that form, is crucial to letting the court know how to contact you and the other person. It also makes it much easier to fill out the vital statistics form, which is another form that you need to file when you are filing the case. If you do not know the answer to something that the confidential information form asks you, write unknown. They will still accept it. If it doesn't apply, and in your case, the questions involving children will not apply, write N/A, meaning not applicable, and the court will understand that doesn't apply. But if you leave blanks, then the court's not going to know whether or not you intentionally left that blank or whether that was just a mistake. So make sure that every box gets some kind of a response, even if it's unknown or not applicable. The other two documents here that you see, the notice regarding military dependent and declaration regarding service members Civil Relief Act, those are documents to advise the other person that if they are protected under one of these acts, that they've been informed as to their rights. Now, if one person is a member of the U.S. military, or in some cases National Guard or Reserve, if they're activated for longer than a certain time, usually 30 days, there are certain rights that kick in to prevent the court from signing a default. If you've notified the other person of their rights and you prove that in your declaration of service, then the court will know that they had the opportunity to announce that they were members of, of the service or protected otherwise under those laws and chose not to file a response. So those are helpful documents for that purpose. The petition and the summons are the critical documents that will start your case. And the critical documents to finalize your case are going to be the findings and conclusion and the final divorce order at the bottom here. But the summons and the petitions start your case. Again, as with the confidential information form, fill out every section, even if it's to indicate that it does not apply or that it is unknown. There are several ways to do service, and the Pierce County Law Library has some videos on how to serve the other person and on questions that come up in service. Chances are you will have, if it's uncontested, the other person should sign the service accepted form, which is where they tell the court that they have been accepted. The reason why this is important is because the 90-day clock to finalize your dissolution does not start to run until both you file the documents and the other person has been served. So make sure they sign the acceptance of service. If for some reason they want to take time and think about it, have someone else serve them the documents, and then file the proof of service. Again, make sure that you're including the military advisories in order to protect yourself from that if that comes up. The other thing that you should do is in the petition itself, if they're going to sign, there's a box that says they do not need to be notified about upcoming events in their case. Have them check that if it's uncontested, and that way you can simply walk in when your case is eligible to be finalized, when that 90 days has run, and the court will not ask you if you've notified the other person because there will be no need to. You can point out that the other person waived their right to be notified. So default motion and default joinder, or sorry, default order are included in this packet. The reason that that might be included is it's possible that even though the other person hasn't told you it would be contested, even though you think you're on friendly terms, maybe you just can't get them to sign it. Well, in that case, assuming that you've done the service or have the acceptance of service, you can still complete your case by filing that motion for default. Now, there's a few important things about the motion for default. First of all, if the other person has appeared in any way, that could be by filing a letter that they wrote to the judge, that could be by participating in a hearing, if they have announced themselves, even by filing a notice of appearance for a self-represented person, or some other way, as I've described above, the court will want you to file that motion and note that for a hearing. That's a 2-week notice requirement, and then you need to prove that you've mailed off that motion for default. If you do it by mail, you have to add in an additional 3 days, so that's actually 17 days. You can also personally serve the motion, in which case you could note it for as little as 2 weeks after you file it. But that motion for default would then allow the court to finalize the case, even if the other person hasn't signed the paperwork. So let's talk about the findings and conclusions in the final divorce order. When you first get this packet, it's a good idea to actually look through everything, including the final documents, just so you see what you're working with, because if you start with the end in mind, you're going to be more complete about your petition. One of the things that I highly encourage you to do is to come up with written agreements that are incorporated as exhibits. If you do that, the court will know exactly what you and the other person have agreed to as far as the division of property and the division of debts, as far as spousal support, as far as any other issues that could affect the marital estate, which if you don't have children, marital estate just refers to property and debts, could include real estate as well. So this is the confidential information form. Again, this is just biographical data. Fill out every section, as I mentioned. This is the notice regarding the military dependent, and here's the declaration regarding the Service Members Civil Relief Act. We've already talked about why those exist to protect military members. This is the summons, and you want to make sure that you check to end your marriage if you're doing a divorce. If you're doing one of these other types of actions, then check that box, but the purpose of this video is for divorces, so I won't go into the other topics here. Now this is important, this page as well. You need to put the court's address here, and you need to put your address or your lawyer's address on this right-hand side. And here's the reason for this. You need to prove to the court that you've told the other person how to file their response if they decide that they no longer agree with what you've put down in the paperwork. So you need to have the court's address. So this would be the Pierce County Superior Court. That's 930 Tacoma Avenue South on the left. And this is your address where you agree to accept service on the right. Put addresses in those sections. Otherwise, you haven't proven to the court that you've advised the other person how to file their documents. By the way, this is covered in the service video as well. When you do in-person summons, then they have 20 days to respond. You need to also prove what documents you've served them with. That is covered in the acceptance of service or in the proof of service. So here's the petition. The petition for, in the case of a marriage does not involve children, you're going to leave large sections blank. You're going to leave the children of marriage section blank, jurisdiction over the children section blank, the parenting plan section blank, and the child support section blank, as well as the children from other relationships. However, I want to draw your attention to section 11. And when I said begin with the end in mind, if you have a written document that you'd like the court to look at the end of the case, you really should also have that available and discussed with your spouse at the beginning of the case when you file. And the type of written agreement, it could be called a community property agreement. It could be more broad and be called a CR2A agreement. And CR2A refers to Civil Rule 2A, and it is what attorneys commonly designate these contracts that people will discuss the case, come up with agreements that they want the court to enforce. So you can call it a CR2A agreement, and the court will know exactly what you mean. The date the agreement was reached, and whether you want the court to enforce that agreement. Now, the real property section is worth discussing because the tax parcel number is going to be found at the assessor's website, the Pierce County Assessor, and you have to have that number here. It'll also have a legal description of the property, which is important for the decree. You can divide real property several ways. You can either award it to one spouse or the other, or you can ask that it be sold and the proceeds divided up. Usually the proceeds would be divided up as of the date of the value of the home at the time that you two physically separate, in other words, when one person moves out. Now, if you have agreements, these property sections become that much easier, and so do the debts, because then you're just referring to section 11, where the debts are. Spousal support, if you don't need it, just check that first box. Otherwise, you would tell the court how much each month, until how long, or until what event. The default event, by the way, in statute is for if the other person remarries, they stop receiving spousal support. Fees and costs, if you want the court to order the other person to pay your fees and costs, and if they agree to that, check that. Otherwise, usually if there's not an income disparity, I recommend just checking no request. If this is agreed, then generally speaking, the protection order and the restraining order did not apply. The name change, talk to your spouse. Both of you can change your names. Neither one of you needs to change your name. That is totally up to you. And you can't force someone else to change their name. So see what the other person wants to do in that case.